wait for her arrival, please. Good evening, everybody, and welcome to this meeting of the Planning Committee, Monday the 7th of October 2024. We shall start with item 1 on the agenda, which is apologies. Can you indicate the apologies received so far?
Apologies received from Councillors Hughes and Patrick, Chair.
Thank you very much indeed. Now moving on to item number 2, which is the minutes of the previous meeting. The minutes have been circulated to you before, and hopefully those present have had an opportunity to read through them. I'm now asking if anybody has any criticisms of the minutes, or comments to make, or matters arising or alterations. In that case, can I ask by a show of hands for those that accept those as a true record of the meeting? Okay,
That's carried.
Thank you. Carried and approved. Right. Declarations of interest. Councillors are reminded of the need to declare any disclosable pecuniary interest that relates to business on the agenda, which have not already been included in the register of interests before any discussion takes place. Unless the interest is sensitive, you must also disclose the nature of the interest. In accordance with the Council's Code of Conduct, you must then leave the room and cannot participate in the discussion on that item. We're now moving on to item number 4, which is the Local Government Access to Information Act. I see no reason at all for excluding either the press or public from any items on the agenda. That being said, we now move on to item number 5. Councillor Millivale.
Thank you, Chair. This application is in my ward, and I've had quite a few discussions with different groups of residents, so I don't think it's appropriate that I sit on this committee this evening, so I wish to recuse myself.
Thank you, Councillor. We accept that. Councillor Hussain.
Thank you, Chair. Same is like Molly. I live on that ward and I know a lot of residents, and I just want to recuse myself.
You're going to recuse yourself as well. Thank you, Councillor. So it's Councillors Millivale and Hussain. I must ask you to leave the room, please. Whereabouts are you going to be again?
Yeah,
I can
Thank you very much. We now move on to item number 5 on the agenda, which is planning application 240655 full at 21 Huntsman Road, Exeter. We will first of all have an officer report and presentation. Thank you. Councillor Pole.
I'm sorry to interrupt, Chair. It's a buzzing noise and I'm finding it a bit distracting, and I don't know.
Like the water machine.
Okay. Shall I move?
It is the water cooling machine. Just switch on that.
Yeah. Thank you very much. Yeah.
Thank you very much. Roger, I understand you're doing the presentation.
Thank you, Chair. So this is an application for a change of use from a residential dwelling in use class C3 to a residential children's home in use class C2 at 21 Huncham Road. So you can see from, this is the application site, the red line, 21 Huncham Road. You can see it has a shared drive with 23 Huncham Road, so 2 detached houses with a shared drive, and you'll be able to see a bit more in photographs in a minute. So this is the location, which I appreciate you can't see very often. That view is a better one here. So again, that's a bit of a clearer view. So you see number 21 with its driveway, and number 23, which is a separate driveway, but both cross over at the same point from the road. 21 Huncham Road is a 5-bedroom dwelling. This is it. So again, you can see the shared crossing point And the garage you can see on the right belongs to number 23 Huncham Road. The garage on the left, which is integral to the house, part of the application site, 21. This is a view taken from standing with your back to 23 Huncham Road, looking down, looking south along Huncham Road. And the application site, when viewed from Cranbrook Walk Junction, and looking east along Huncham Road from the application site. It's just some photographs of the internal arrangements of the house, which, as you can see, is a typical home. And that's the garden. Floor plan. So you can see it's got a garage, dining room, kitchen area, lounge, study on the ground floor, and bedrooms, bathrooms on the first floor. So as I said, the application is for a change of use to a residential children's home for up to 3 children between 7 and 17 years old. There'll be 3 adults in the home to support them alongside a manager. So there'll be up to 7 people in the house throughout the day, and up to 6, including the children, overnight. We've had no objections from Devon and Cornwall Police, no objection from the County Council on Highway Grounds, and no objection from the Devon and Somerset, Fire and Rescue Service. There's been 56 objections and a petition with 153 signatures on a range of grounds, including parking and access, traffic movements, neighbourhood concerns, and fire risk. So on the screen before you are the key planning issues. We recognise there's been a range of other issues that have been raised in connection with this application as well. And we've taken those very seriously and examined them. Hopefully you'll see from the report that we've looked at those issues. But there are 3 key issues which are material planning considerations to be focused on in making a decision today. Firstly, the principle of the change of use. Specialist housing planning uses, including C2 uses, are generally considered to be acceptable in residential areas and are supported by a range of local and national planning policies. Access, parking and other highway issues. The highway officer has no objection. The proposal is likely to generate similar levels of vehicle movements to the existing dwelling. And the impact on neighbours' amenity. Given the limited number of children and number of staff and the space within the property and the size of the garden, the proposed use will not harm neighbours' amenities and would be very much like the activity generated by a family occupation of the property. And the planning system does not judge potential behaviour of individual occupants because of their age or background. There's been no objections from the police. Before moving on to the recommendation, I just want to touch on some correspondence that's been received today in connection with this proposal. Firstly, an email questioning whether the application was valid and whether it should have been registered. We've examined this and we are satisfied that it was valid when it was registered. And secondly, an email further questioning the highways, the health and safety implications of traffic movements associated with the proposal. Again, following advice from the Highway Authority and our consideration that the activity is likely to be very similar to a 5-bedroom family dwelling, we don't believe that there are any serious health and safety aspects arising from traffic movements, which would be much like the residential occupation of the site as a family home. So the recommendation is to grant planning permission subject to conditions, including 3 in particular, which are relevant to appropriate control of the use, ensuring there are no more than 3 children occupying the property at any one time, that it should only be used as a children's home within use class C2, and a requirement to provide a green travel plan to minimise the unnecessary movement of vehicles associated with the development. Thank you, Chair.
Thank you, Roger. Members, at this stage, I invite you to ask questions, and I see Councillor Bennett and Councillor Atkinson. Councillor Bennett first, please.
Thank you, Chair. Could you just confirm or clarify with me about the covenant on the residential area and where it stands within the planning policy and the legal side, please.
Thank you. The covenant would not be a relevant material consideration in determining a planning application. It would be a completely separate legal matter which would not be enforced by the council. So we cannot enforce the covenant. We don't have any specific knowledge of it. And this meeting is only to determine the land use and the use of the building.
Any follow-up question, Councillor Atkinson?
Yeah. I have one question, and then if I could follow up after that. I note from the delegation briefing that there has been some previous occupation of this site. Is that right? Was that as a children's home? And were children living there, but it hadn't actually got permitted use as a children's home?
As far as I know, there was an application for a lawful use certificate for use as a children's home, which the council refused. I don't actually know whether it's been occupied by children as a children's home.
I think it was granted initially.
There was some confusion about the lawful the decision we issued. I'm afraid I don't know whether it's actually been occupied by children, but that wouldn't be a determining factor in determining this application.
I totally understand that. My question was if it had been occupied while this process was going on, had there been any complaints. I must say, as a corporate parent here, I'm speaking as a Devon County councillor, I'm greatly saddened by the number of objections to having looked after children.
Councillor, can I ask you to confine your comments to questions of clarification to the officer? Thank you.
Okay, right. In that case, I won't say anything further, but except
At this
to say at this stage that I would like to say further comments on your presentations. Thank you.
Councillor Banyard.
Can I just ask a question about the shared driveway with next door? Can you explain, does each house have a particular portion assigned to them, or is it, how does that work with the neighbours?
As I understand it, I can go back to the slide. They have a portion amount each that they legally own, but then have a right of way. They both have a right of way to cross the bits that they don't own, if that makes sense.
Yes, I see how that works now. Thank you.
Thank you, Councillor. Councillor Jobson.
Thank you. I've been made aware of an email that was sent to the planning department.
Can I just ask if you can get access to a microphone, please?
Yeah. Sorry. I've been made aware of an email about a certificate B. And just wondered what the answer to that was. I don't know what a certificate B is, and I suspect nobody here does. Perhaps if it's very quick to explain what it is and why it is or isn't needed in this case.
I'll do my best, and that's actually what I was alluding to earlier. But a certificate is a certificate of ownership that you have to submit with your planning application. So if you as the applicant are not the owner of the land, you have to certify and notify anybody who is an owner of any part of the land other than yourself. So you serve certificate B on owners who aren't you. You see what I mean? When you're the applicant. In this case, the site is owned by someone who isn't the applicant. So the applicant correctly served notice on the owner of the land. There was a question that we received this morning by email about whether the owner of the neighbouring property should have been also served as an owner of the land. And in looking into it, that neighbour has a right of way, but doesn't own any of the land within the red line submitted with the application. So we believe that the correct certificate was served to the right person, and there was nothing incorrect about the way that was done, and therefore it was correct to have validated the application on receipt.
Thank you. Councillor Pole.
Is it appropriate to ask at this stage about the provision that we have for looked after children and children in care, and how this application serves those needs in the housing supply?
I think that is a question for later when we're in discussion about the whole application. I would like for us just to have comments on the presentation as made by the officer.
Okay, thank you.
Councillor Ralston.
Thank you, Chair. Can I just ask for a point of clarification? Is there access to the back of the property? Or is it all just through that shared right-of-way drive?
As far as I know, there's no other access to the application site other than via the drive.
Any other comments on the presentation? Councillor Mitchell.
Thank you, Chair. We recently had a similar application in Newtown St Leonard's, which went on for some time. And in that case, because the County Council were involved, we did have a report, or I believe comments from Devon County Council Social Services. And I'm just wondering, in relation to this being a residential children's home, are they required, or do we not require any comment from them in regard to such an application?
There's no statutory requirement to consult them on an application like this, and because they weren't involved in making the application, there's no need to seek their views.
Thank you very much. Are there any further questions of the officer regarding the presentation? In that case, I would like to move to our public forum statements. I have a request from a councillor, Councillor Duncan Wood, to speak under Standing Order 44. Councillor Wood. Councillor Wood, I will remind you that whilst you do not have a time limit, unlike other people, I would ask you to keep your comments to the point and relevant to the presentation and the application. Thank you.
Thank you. Feedback. Okay. Thank you. I'm speaking here on behalf of a large number of residents within the estate in which this will occur, but also on the properties that back onto it from the Hill Barton Road, which are older established properties. So you have two different types of residencies. You have the new estate, of which this is a part, which is comparatively new, and then you have the older properties that have been there for quite some time at the back onto it. So it's on the border between those two. So you can see from the papers that you received that there were 56 objections which went in through the normal planning portal, which you've been able to access. In addition to that, there are 153 signatures from across the estate and also beyond, as I was saying, from some residents in the older properties. So speaking on their behalf with their reservations, item 11 on the papers gives a fuller list of their reservations and concerns than was in the original display. Although I'm quite conscious that some of that was summarising, but there is a longer list of issues, and I think in summary, there's a degree of fear of the unknown, and obviously I think I speak on behalf of a number of the residents where we would very much like to see children in care in a safe and comfortable environment. They are, as Councillor Atkinson has said, we are corporate parents to them within the council, but also the residents recognise there is a need for young people who have been potentially through quite difficult situations to have somewhere safe and comfortable to live. Having said that, my residents have approached me with issues about this particular siting. It is in the corner of a quite restricted road. We've seen some of the photographs, which actually make the road look bigger than it is. It's one that, you all know as ward councillors, you get to pound a lot of roads. I've been down this road and quite a number of times. It's mentioned in the in that long list under item 11. There are no pavements, and there aren't. It is one of those developments where I think there was an attempt by design to design out car use. Unfortunately, the general public, including me, didn't get that memo, so I've still got a car, as do many of the residents here. So although there are some drives, there is quite a lot of parking that goes on. There are shift workers who will be there, so it's not the same as somebody living within the home. There will be overlap of staff. With the upper age range of young people who could be here is 17. You can drive at 17. There is potential for additional cars on that basis. The roads, although Devon County Council have not raised an objection, and I know if they don't, we can't, but we often get hampered with that particular issue. It is quite constrained streets, and I do have some concerns over further blocking of that road. It mentions under 11 as well, they're concerned about emergency vehicles, which obviously is a byproduct of a road not designed with pavements, not designed for a lot of cars, having a lot of cars parked on it. And whilst I recognise that this development won't be the sole cause, it could be the icing on the cake, if you like. So there are a large number of different objections. I recognise that a lot of them don't fall into the realms of the planning framework, that we can't consider them. I also recognise that the police have not raised issues against some of the reservations that the residents have, but 153 is a significant number of residents, and I guess I got a degree of concern. I think that what we're agreeing to is to put vulnerable young people into a setting in which I kind of get the feeling they're not welcome, and that concerns me. So I wouldn't want them to be brought into a community which doesn't welcome them. So there's that consideration that I just want to kind of put on the table. 153 is quite a high number. I know in planning terms we are kind of a little constrained, or you are constrained as to what you can, the choices you can make, the basis on which you can make the decision to approve or refuse. Your hands are tied, and I get that. But speaking on behalf of my residents, there are a number of concerns that they've raised, and the public speaker that comes after me will clarify more of those reservations. I'm not sure there's much more I can say. I think there was a question as to whether there's access to the back. There is no vehicular access to the back, but there is a walkthrough. So yeah. So I'm not sure there's a great deal more that I can say unless anybody's got any questions.
Thank you, Councillor Wood. I now invite members to ask questions. Please keep your questions to the points raised in the presentation or comments by Councillor Wood. Councillor Wilson.
Sorry, Councillor Atkins, I'll be just by a second. Your question, the comments you made about increasing traffic flow, do we really think it's going to increase it more than a household that would occupy that size property if they were just buying it as a family home? And also, my understanding of the shift workers is that they will work kind of 24 or even 48-hour shifts, and therefore probably wouldn't be using their own cars to work with the children or take them out anywhere. So surely that would lessen the in and outs, because you wouldn't have somebody who's working, 8 till 5 and does that make sense?
It does. I think, it's a 5-bedroom house, so it's a fair point that there may well be more than, in its normal use, there might have been, if it was full, there might be more adults than might otherwise be said. I think, one of the things that's mentioned in the papers is a management plan for the premises. And obviously within that, there should be a designated community liaison, especially given the the resistance from the community for this project. So I would hope that there is going to be some direct connection between the management of this premises and the surrounding community. That would help to alleviate the kind of parking concerns, hopefully, or give a channel through which issues can be raised if if there is a lot of on-street parking, because it's a bit of a weird one, because effectively this is now a commercial enterprise. This is now a business, and it's got shared access with a residential property, which is a bit weird. And as you can see from the drawing, the residential premises next to it has actually got basically space for a car, that most of the other tarmacked area is not. It actually will be run by the business. And so therefore, I think parking could become an issue. Would it be more than if you had the 5 rooms full of 5 adults? Probably not. But changeover of shifts could lead to 2 cars being in the road at any time. There is a green travel plan being required as part of it. I think I would like to, under the perhaps from what you've raised, it might be useful if the conditions also included reference to a community liaison or contact point between the company and the general community, because I think this is a bridge that needs to be crossed. We need to have some connectivity. If this goes through, the 153 people need to have a way in to raise issues on transport or on anything that any of the concerns they've raised. If they come to fruition, the community needs a way to raise those cleanly and quickly. Thank you.
Thank you, Councillor Atkinson.
Thank you. Look at it from the safety aspect in relation to children being there. There's no access from behind, so an enclosed garden in a cul-de-sac. So would this not be actually quite an ideal situation from the? I'll repeat that. Look at it from the safety aspect. From the children, the 3 children who are going to be living there. There's no access from the garden. It's an enclosed garden. It's in a cul-de-sac. Therefore, it's almost an ideal location from the safety of the children's aspects. I don't know if you'd agree with that. You've already answered the question. You could have 5 or 6 adults, each with a car. And we've got the aerial view here. And not all of the parking is necessarily going to be, could potentially be in Huntsman's Road. I mean, there's Cranbrook Walk, and I can see from the aerial photograph in the presentation, there's quite a few cars already parked down there, around there, and I've no idea when this was taken. But you've heard Devon County Council. There is not necessarily an issue with parking in this area, and you can't just. And it's right, isn't it, that people don't have the right necessarily to park outside their house. If it's a highway, anyone can park there. So in theory, you could have somebody coming in from Cranbrook parking their car there and working in Exeter. So so the parking itself is not necessarily an issue if you look at the bigger perspective of the whole area. And if that were to be a problem, is it not also right that they do have a way in through the Devon County Council to ask for residence parking permits, for instance? And one last question. You talked about concern about the management of this. It's right, isn't it, that children's homes are regulated by Ofsted? Therefore, you've not only got regulation by Ofsted looking at how this site is managed, the safety of the children and the environment in which they exist, the safety of the providers, but also you've got county council officers through their fostering and adoption services, vetting accommodation and suitability before any placements are made. So what other safeguards, I mean, the police aren't concerned, so what other safeguards could you possibly ask for that isn't already existing?
Okay.
Yeah.
Thank you. You might yeah. Okay. Yeah. So transport first and parking. You're quite right that anybody can park anywhere. That already happens. So you kind of have to, whilst you're writing that, that's already happening. That if somebody wants to work in Cranbrook, they are parked there. They're already doing it. It is about the impact, I think, of specific use that demonstrates it. I mean, when a residential home, if somebody lives in a home, they use it as much as they do. And I know that in a number of estates we have in Pinho, you've got a family home of which if there are two parents there, they may both have a car, and one of the adults may also have a works van. It happens. So you've got three vehicles for one house. And I know that a number of the developments we have in Pinho really are not designed with that in mind. It can be quite a problem. And it's also a problem that moves out into other areas. So if you can't park outside your house or even in your road, then you just look for wherever you can park. So parking is under pressure within Pinho. This is a commercial enterprise. It is not a private home. And therefore, there is a potential for, I think, parking that may go beyond what could happen in the house. I don't know. But the problem, I think, with this is the decision gets made tonight. And if some of the concerns around parking, etc., do come to fruition, yes, they could apply for residents only parking, but we all know the level of consultation that's required in that. Even getting double yellows painted down the road would be a long drawn out process, which is not guaranteed in any kind of result. So a parking concern, I don't think, is alleviated by the fact that it is potential that you could get residents parking only. I think it's a tool, but it's not guaranteed to land. It's very time consuming. And yeah, there are parking issues all across the city, and they're not easily solved. And that's not always a route that does work anyway, because it often displaces the parking into neighbouring areas or neighbouring roads. So you also mentioned, I think, about the community liaison, Ofsted, and county council officers having oversight of their primary focus, as is right and proper, is the ensuring that the vulnerable young people are properly cared for, are safe, are in a good environment, a good residential setting. And this building, looking at the pictures, looking at the size of the garden, as you say, it's a great place. In isolation, when you look at that, it's spot on. What we have got is a established community which has become aware of this. It's quite a significant change. As has been mentioned, it's against the covenants that cover all of the homes they bought. So there's a bit of a surprise there that business is now going to be set up within what they viewed as a cast iron residential area. So there are some issues there, and I think that it just would help if the management were prepared to be required to have a formal line of communication with residents if they raised issues, because Ofsted won't get involved in you keep parking across my drive, and neither will Devon County Council officers. It's the sort of niggly thing that winds us all up as with our neighbours. From time to time, neighbours can do things that are annoying. This community's expressed its concerns and reservations about this development. So I think just having a channel that is written in that they will have an opportunity to raise issues with this business if this business's activities impact on their life quality in their homes. So it just seems reasonable that there is, if it was a pub, for example, if I was on licensing looking at setting a pub up here, I would be expecting the business to make clear how you could contact that business to raise concerns about how they are operating. That's just kind of what you sort of expect with a business, that they make clear, if you've got a problem, talk to me. Does that answer the question?
Councillor Poll.
Yeah, so thanks very much, Councillor Wood. And I'm just like grappling a little bit with some of these analogies. Is there any evidence that we're going to have people? This is a 5-bedroom family house with 3 children living in it. And I know you say it's a business, but in a way it's a business because we live in an age of sort of privatisation. I mean, I have half a century of experience of it being quite normal to have residential children's or even adults sort of homes pepper potted into the community. And I don't think there's anything sort of radical or sort of very innovative sort of happening in this particular case. I think I'm not sure if there's any evidence that there were going to be vans parked there. My reading was that there was going to be 1 adult sleeping there overnight. And my experience with this particular, it's close to my ward, so it seems like a very, it's from looking at crime maps, it seems like a very safe area comparatively. It seems very walkable. There's a supermarket, a school, a play area nearby. It isn't a pub. I just wonder whether these sort of, whether there's any sort of evidence of this sort of being run like a business rather than a family, and whether or not there is any sort of real expectation of these sort of vans and delivery vans and sort of kegs of beer and things sort of turning up. I think it seems like a livable area. If there's a green travel plan, I can't really see why there needs to be any particular increased car use from the presentation that's in front of us. And I just wonder if you've got any other information about that.
Thank you.
Thank you. Yes, I think noisy thing. I think with regard to is this a business? Is it something we would normally see? There are a number of different, there are a few different models that can be used in this sort of setting, and it is a business-based solution that this follows. When it was originally submitted, there was, I think, some misunderstanding of the setup, and it was originally going to be given change of use as a lawful, because that model was, if I can't remember exactly, in the office probably can provide this information, that there are different models, and if there was an individual there, house parent shall we say, who just lived there, and the young people lived with them I think that's a lawful change of use. It's when it's shift work, when it's more structured, as you might expect from a business, you know, with paid staff that have a shift and then go home. That changes the status of the application, and so therefore that's why it's here. Otherwise, it could be, it wouldn't be, I don't think, applying for permission. I think it would be just given lawful use category. So it is different. It is different. And the other question was around the transport issue again. I'm not thinking delivery trips. I mean, obviously, I think the number of times I see an Amazon truck go up and down my road, I think it'd be hard pressed to beat it. I think it's more around parking. And there is one adult staying overnight. Now, obviously, this isn't their home, so they will park a car, as you might expect. So that's, you know, and whoever lived in there would anyway, and I suspect the car would be on the driveway off the road. I think it's when the driveway is full, where you've got visiting relatives potentially. I don't know, but it is a business and it is a different profile of use than the house next door. So just to raise that, and it's the concerns of my residents that I'm listening to and I'm presenting here. They live in this area. I don't, so I'm listening to what they're saying, and they have concerns about it, which I'm presenting to you guys.
Councillor Paul, continue.
Yeah, I very much appreciate you representing the views of the residents, of course. But well, so first of all, is it necessary that the shift workers are going to be arriving by car if there's a green travel plan? You know, they're not going to necessarily have sort of 2 cars and a van parked there because they're not a family staying there overnight. And so in a way would reduce the number of cars that were there sort of in the evening compared to sort of an ordinary a household that was where the parents were sleeping in the house, and perhaps had a work van, like you said earlier. Am I correct though, from looking at the plans earlier, that there are 2 garages, and are they still garages, or are they converted into something else? Because I think they were presentation was that we had a double garage and that there's room for 2 cars parked in the garages. So that's just another question I had about this concern about the parking.
I know it's questions to me, but with the chair's agreement, the officer may be able to answer that last part.
Thank you, Councillor Wood. Would you care to make a comment?
I've not personally seen inside behind those garage doors, so I don't know whether there is room in there to park a vehicle. But the plans that were submitted with this application indicate that that's still a garage. It's not allocated or converted to anything other than garage.
Yes, certainly that looking at the plan shows those as a double garage space and obviously space for 2 cars in front. Councillor Ralston.
Sorry, Chair, could I answer there's a 2-parter. I'm just trying to remember the 2-part word now. A green travel plan. It's not in the same structure of a green travel plan as you would have, say, at the council. Reading the papers, it seemed to be that the company have committed to raise awareness of travel options. So it's not quite the same as a travel plan as we would expect to see one. So just clarifying that.
If I could just interject, I mean, the green travel plan is conditioned, and so therefore it is in place. How they interpret the green travel plan obviously is another matter, but I know it is part of the conditions. Councillor Ralston.
Thank you, Chair. So for clarification, because you touched on it, Councillor, possibly not for you, but to the officers about this lawful change versus planning permission. If we had a couple who were deciding to privately foster 3 children, there would be no need for planning consent for this. This is mainly around the fact that it's actually a business who are not only going to have social care overviewing what they're doing, but also Ofsted, so more potential safety measures in place. And it's because of that definition, because it's a business that's in effect privately fostering these children with the other staff. Whereas if it was a private fostering for a private family who are having 3 teenagers, that we wouldn't be here. Is that correct? Is that what you mean by that sort of difference?
Yeah, you've got it exactly right. Yeah.
If I can add to that as a question to me, I think the difference, and probably why the law requires that identifies that there is a difference, is if you had two adults living there and chose to foster children, then that becomes their home, and we view our home differently to our workplace. And the individual who will be the house parent, if you like, that is their place of business. They can choose to resign and move on. It's a different feel, and I think that's why the law identifies that there is a difference. So whilst I fully recognise that 2 people fostering 3 children, no decision for this body to make, it just happens. But because it is a business, I think that changes the nature of the game, but it also raises concerns with neighbours. So I think a community liaison required from the company will do no harm. And if the company runs its business in the way it says it will, that individual will have nothing to do. But if things go wrong sometimes, new member of staff doesn't quite understand their role, then somebody, an identified contact for local community to approach, seems a reasonable safety measure to build in response to 153 signatories on a petition. Just an observation.
Just can I follow up?
Councillor Ralston first, then Councillor Atkinson, please.
With my knowledge of residential children's homes and things, and my understanding is that regardless of the size and the amount of children, it has to have a licensed manager who has to have a certain level of qualification. So surely they would naturally be the point of contact for anybody, I would have thought, as opposed to, is that what you mean, rather than having somebody extra? Because that just seems like way too many adults to have to be involved. But a named contact, which was most likely the manager, who will also have other responsibilities as the manager and having to have a certain level of qualification and experience, would be there anyway, wouldn't they?
Yeah, I think with these things are playing up. I think with the same, and I know it's not a pub, but I'm on licensing, so that's how I connect to it. I think in terms of relationship with surrounding residents, having that name, knowing that name is important. Not to say they employ somebody just for that role, but the individuals who live around it to know who to talk to, because staff there is a turnover. If we go back to the scenario where you have 2 adults who are fostering children, you kind of know that Mrs. Jones lives there. So if you've got a question or a concern, you ring on the doorbell and ask for Mrs. Jones. She lives there. You know her. She's your neighbour. But staff can turn over, and if you ring on the doorbell at 2 o'clock in the afternoon, you may well speak to somebody different if you go round at 9 o'clock at night. So having a named contact that people can recognise and approach and use just makes sense, really, to me. But like you say, if there is already a role that fits, it's just a matter of, I think, requiring the business to make that contact known to the wider community, as you would with a pub.
Thank you, Councillor. I do feel that we're revolving around the same conversation. Okay, so I'm going to see Councillor Atkinson, Councillor Banyard, and then I'd like to draw a line under this.
Mine is questions of planning officer. I'm not sure that is, I want to this is a request that there be a named individual who is a responsible.
Councillor Atkinson, you are able to make, during debate, you're able to
No, I'm
impose
just going to ask if
conditions.
that's a valid planning condition, which we could impose, just for clarification. And then just that would, perhaps say one way or the other whether that's a valid suggestion that's being made here.
So I accept your point, but I say this is not the appropriate time in the conversation to bring that up. When we get to the stage where we can look at changing conditions or having alternative motions, then that's when we can take that in. At the moment, we are questioning Councillor Wood on his presentation.
I was just a question of law.
Councillor Banyard.
Can I ask about the petition? So talked about the petition with 153 signatures. What was the question or the thing that the petition was asking? Was there a particular statement that people were? Can you tell us more about what people were signing to say with that petition, please?
That's a very good point, and I'm afraid I don't have the answer to that. I wasn't involved in putting the petition together, so I cannot answer that question. When the public speaker comes up, obviously he may well be able to answer that question, but he's only got a short. He's time limited in what he can say. So yeah, I'm sorry, I can't answer that.
Well, Councillor Banyard, you can ask that as a question after the presentation by the speaker. Thank you. Are there any other questions of Councillor Wood, please? Councillor Shannon.
Sorry, it's not really a question, it's a point. Could we stop comparing 3 children to a pub, please? Thank you.
My apologies. That was a analogy that sneaked in because of my role elsewhere in the council, which is licensing. My apologies.
Thank you, Councillor Wood. I believe that we have exhausted our questions of you. Thank you very much indeed. I can step down, please. We now move on to the speakers. We're going to go for the objector first. So can I call Mr. Omar Salam, please, to the table? Thank you. So, Mr. Salam, first of all, in order to be able to speak, you need to be able to press the buttons on the machine. We will be as lenient with you on time as possible, but you are restricted to 3 minutes. You just wait for us to set it all up for you. Thank you. Thank you very much indeed, sir.
So I'm speaking on behalf of 158 signatories to a petition that objects to this proposal. We believe that the planning officer has given materially misleading information to the committee. The planning officer has also failed to discharge the council's Thameside duty in the same way that was judged by Mrs. Justice Lang in February this year in Pratt versus Exeter City Council. The planning officer has failed to consult with the actual landowner who is responsible for this road. The landowner has placed a legal obligation on all of the properties not to be used for any use class other than C3. I direct you to the supplementary information that I provided you with this morning by email that represents the already increasingly worsening parking problems and a health and safety risk that has been already highlighted by Exeter City Council. The proposal has been labelled by the planning officer throughout this report as a children's home, which is not a category of use class. This proposal is for a class C2 residential institution, which specifically caters for residents with mental health problems and substance abuse. Devon and Cornwall Police have requested more information from the planning officer, which the planning officer has failed to provide, instead choosing to state the police have no objections. Devon and Cornwall Police have stated that antisocial behaviour and missing persons reports where residents effectively run away from this type of institution is very common. In fact, the applicant has another site at 63 Burrowhall Drive where an example, a resident escaped 22 times in just 9 weeks. This site is currently operating unlawfully as Class C3 use, and that is known by the planning officer and the applicant to be unlawful. This proposal backs onto 7 neighbouring gardens, which will be the most likely route of escape for these residents of this institution. This type of regular activity will have a very detrimental effect in terms of the loss of privacy and disturbance to the neighbouring properties. The site's L-shaped garden makes it extremely difficult to supervise residents, as highlighted as absolutely necessary at all times in the police report. This proposal will involve a staff changeover of at least 6 members of staff twice a day, 7 days a week. This has been acknowledged by the applicant's statement. In addition to this, there would be the comings and goings of young people themselves, together with staff, carers, families and friends. The narrow shared driveway is visible from all adjacent dwellings, which would cause frequent and unacceptable levels of noise disturbance to the neighbouring properties, including twice daily changes, including weekends. Also, regular fire drills will create extra disturbance and noise.
Can you briefly conclude, please? Your time's up.
Sure. The narrow shared driveway serving both 21 and 23 lacks sufficient space for more than 2 vehicles to park in front of number 21. This would mean that parked cars would obstruct access to number 23 and its designated parking spaces, directly impacting the neighbours' amenity. Also, in the local Exeter plan, H14 aims to protect privacy and overlooking noise disturbance and the ability for one to feel at ease in their home and garden. Also, Exeter's local plan policy H11 prevents a loss of residential accommodation, and this is a loss of residential accommodation.
Thank you very much indeed, Mr. Salam. I now invite members of this committee to offer questions to Mr. Salam on his comments. Councillor Bannion.
May I just ask again about the petition and what the wording on the petition was, what the residents thought they were signing to agree or disagree with on it?
Sure. The petition is on the council website. I would have thought that you would have been furnished with that, but perhaps not. It basically asked the question or pointed out all of the planning issues that were felt relevant to the site, which Councillor Wood has already pointed out, mainly things like parking, access, increased noise levels, and the existing health and safety problem that Exeter City Council have highlighted. And in agreement with David Wilson Homes, who are the landowner, they've also already sought to make restrictions in this area, this specific area. So they were all listed, and then if people chose to sign that petition, they were effectively saying, we agree that this is going to create a bigger problem for us.
Thank you. If I could just make a point, please, before we continue. I have been in consultation today and can find no record by Exeter City Council of any objection on health and safety grounds or parking there. Can you please provide or give me information as to who it is that has actually made this statement from Exeter City Council?
I emailed a letter from David Wilson Homes to you all this morning, and in that letter it quotes, I quote that verbatim, that they are saying that they have been in consultation with Exeter City Council and you have all agreed that there is an existing health and safety problem due to the lack of parking and the lack of footways. You've got a copy of that letter, sorry.
I've got a copy of your letter. However, there is nobody in Exeter City Council who has any reference or recollection of this. If you could helpfully provide the officer who dealt with this so that we can follow this up, I would be grateful.
Well, I don't think you've spoken to every employee of Exeter City Council today, and I'm afraid I don't know the individual person that dealt with David Wilson Homes on that. I can perhaps try and find out, but I suspect it's going to be too late for this evening.
I shall refer to the officer if you'd like to make a comment on that, because I presume this sort of conversation would have had to been had with either planning or city development.
Yes, well, for one thing, I don't think we would have any control over anything unless there was a breach of the original planning permission for the development. To my knowledge, we've not taken any enforcement action about the compliance with the design of the original development, and we wouldn't get involved in any health and safety implications of particular parking arrangements, which would be a matter for the police. So no, there's been no involvement of city development I'm aware of in connection with this particular issue of health and safety related to parking and traffic movements.
Thank you. So that's city development that we're talking about, I think. Councillor Atkins.
Yeah, thank you. In regard to the parking, I've already mentioned it's obviously if there's obstruction of the highway, it's a police matter. So you could always ask the police to investigate. That's right, isn't it? And also the health and safety aspects that you're alluding to in terms of lack of pavements. Clearly, that was an integral part of the design, as Councillor Wood associated to. So it wouldn't have got planning permission at that stage if it had been unsafe for residents to walk up and down there, I'm assuming. Also, the Devon County Council Highways have made no objections on health and safety grounds. So do you think you should reconsider, that statement that it is unsafe? That's my first question.
Can I take one at a time?
Fair enough, yep.
You mentioned the planning application, and I completely thank you. I completely agree with you. But what you need to understand is when this was proposed and accepted by the City Council, it was designed to be a purely residential estate. There were no businesses supposed to be functioning in that street, particularly in that area. And that's why the developer and the current landowner, David Wilson Homes, has a protection against this type of business opening up as a restrictive covenant to prevent it. Now, I understand your position is that you may not have to abide by a restrictive covenant. However, I would urge you that a restrictive covenant is put in place for a reason, and it's put in place to protect the members of the public that fall within Exeter City boundaries.
Thank you. My second question actually relates to this restrictive covenant, which you rely on. I've had lots of dealings as a councillor with David Wilson Homes, who actually once they built it, don't take much interest in finishing it or any of the concerns that happen on these, in my opinion of them. And then if we look at this restrictive covenant, which we say is not relevant in any event to the planning application today, it's right, isn't it, that somebody who's subject to a restrictive covenant could also apply to the Lands Tribunal to say that that it can be removed because it impedes the reasonable use of the land. And in this instance, the use of the land, okay, by a business, but is as a residence for young people. So are you really suggesting that if the business were to somehow get planning, that the restrictive covenant couldn't be overcome?
It's possible that a restrictive covenant can be overcome, but it is also possible that an individual can enforce legally a restrictive covenant, which unfortunately will be what is going to happen should this committee be minded to approve this. But that comes with great expense and great costs on both sides. I think what some people who perhaps work in children's care are failing to understand, that this type of arrangement is for a residential institution which has been specified by the applicant to cater for young adults with mental health issues and substance abuse. Now, the applicant didn't need to choose those SIT codes, they did. They will have their commercial reasons for doing so. I'm not against children's homes. I'm not against children's homes in the right place, in the right setting, with the right parameters. More importantly, for the children themselves. The children themselves need to be safe and secure and not affected by the sort of problems that this will create. But this location is the wrong location. That's what our argument is. It's not the wrong thing to do socially, but it's absolutely the wrong location. How can you run a business on shared land with a resident, i.e. my property? I have therefore no say in how other people are using the shared element of my property. And I don't think that's right. And I don't think the planning laws, when applied common sense, would allow that.
Well, just a few more questions. And I mean, obviously, if you had any neighbour in a shared use, obviously, you still have no right over your neighbour's right of way, except if they were impeding your access. So I hope you'd agree that you're in no different position to anybody else who shares a right of way. But my last question, I'm glad you're now referring to this as a home for children, because your presentation to us really did paint the picture of these being mentally ill criminals, defective, who are raving mad and who are going to cause a lot of problems. And do you think that's slightly offensive, because we are talking about children here?
If I'd have said any of those words, I would agree with you that was offensive. I never, and that recording will prove, said any of those words. What I said to you, and I can read it back to you, is that this is not a fluffy children's home looking after poor little Tilly, whose mum and dad have died sadly in a car crash. This is set up by the applicant's own submissions to cater for. It's a residential institution that specifically caters for residents with mental health problems and substance abuse. Again, those issues do need to be dealt with. What we're saying is not in this particular location, when it's surrounded by other young children and a lot of elderly people as well. This is all about choosing the right location for this very specific problem. And it is a problem and it needs to be dealt with. But you have to think about what you would be agreeing. You're effectively leaving that problem with a lot of very vulnerable other people, young and the elderly.
Yeah, thank you. Going to deal in turn. I have Councillor Mitchell first, and then Councillor Ketchin.
Thank you for your presentation. At the beginning, you spent quite a bit of time talking about the police and reports, etc. We as members, and I expect you've seen it, have got a report from the police, a summary of the report, I expect, from the police in front of us, where they raise a number of issues and then indicate how these issues might be resolved and mediated in some format. And with a general comment of no observation, could you please clarify what you were saying that, in effect, we have not got in this report that you believe we should have in this report?
So the planning officer, kind of cut and pasted what the Devon and Cornwall Designing Out of Crime officer submitted. But the planning officer, perhaps deliberately, decided to remove a paragraph. And you will, if you see the letter that's on the planning site, be able to see it for yourself, because the planning officer effectively is asking the planning officer to provide them with more information. And it's an absolute request. Please, can I have more information about certain things? And we've spoken to the Devon and Cornwall officer, who's confirmed that information wasn't provided. Now, his main concern, and he goes on to say this, the Devon and Cornwall police officer, their main concern is one of what they call running away. Now, when these poor young people are often put into these care homes, again, no fault of their own, but it's very, very common for them to what they call run away or escape. Now, this applicant has already got another home in Burratool Drive, I believe it's in Exwick Ward. In 9 weeks, they had one resident who escaped 22 times. Now, what that activity means, unfortunately, is that they'll have to do a missing persons report. A police officer might have to find them from wherever they are and bring them back to the home. That is not reasonable use in a residential environment. Now, he's concerned that that's likely to happen again. One of the comments he's also made that I don't believe has been included is that he's insisting or making a recommendation that children must be at all times supervised in the back garden. Now that's so. If that happens, if a child wants to run away, They can't get out through the front, as this councillor has already pointed out as an advantage. They're going to go over the back. And on that map, you've got 7 houses with elderly people or young families with young children who potentially might have to deal with a young adult, 17 years old, who has mental health problems and has substance abuse issues, jumping over a fence to run away through someone else's property. Now, when everybody signed up for these properties in a residential area, they took a lot of comfort in the fact that that was not an issue to be worried about. And that's what the police officer was focused on getting more information about, and it wasn't given to him by the planning officer.
Thank you. Thank you for that. We can follow up on that in our debate later. The second point is you quite aptly used the phrase right place, right homes, which is taken again from the ministerial statement. Where in Exeter is the right place and the right for these people?
I take a guess of how many houses there are in this city. 80,000, 90,000, 50,000. It's in the tens of thousands. I would like to think that there are more suitable properties to use for a children's residential institution, focusing on children with mental health issues and substance abuse. In my opinion, it should be a detached property that is enclosed so that the children feel secure, so that the children feel safe. If there are any problems in there that you're potentially saying Ofsted will be able to regulate against, it will be isolated within one property, not walking over someone else's drive in an escape room. That is a very closely bunched together property, as is familiar with new builds, because it's all about how much money we can make as a developer. There are hundreds of properties. This is just an opportunistic applicant with an opportunistic landlord who will be getting twice the normal rent. This is a financial instrument, and better homes and better places are easily available throughout this city.
And I've got a list now, so Councillor Ketchin, please.
I'm not sure if it's material or not, but you did allude that this is already in place and that there are cared for children there. If that is correct, can you allude to, have the police been involved in problems? Have you had problems? Have the police taken statements, and therefore there's a profile of problems that the police haven't reported to us in their submission?
I haven't alluded to that. At this particular site, there are no children there, and there haven't been. What I alluded to is the applicant company have another site in Exeter that is currently operating under C3B use class unlawfully. The distinction between, you should guys maybe know more than this, but C3B, the carers have to permanently reside in the home as their main residence. They've got their lawful development certificate through to operate in Burrator Drive, but we know for a fact that they are actually operating under shift patterns. So that's now an illegally or unlawfully operated site, not this site that we're talking about tonight.
That's very helpful, thank you.
Councillor Bashu. Councillor Pole.
So I feel like looking at the documentation that I have in front of me, I'm looking at a planning application for a residential home for children between the ages of 7 and 17. And I'm trying to search through all the documentation that's in front of me to find these reference to it being for the specific use of housing children with mental illnesses and substance abuses specifically. And am I missing a document that's explaining that? Because that's not the documentation that I've got in front of me. I would also just like to sort of, put that in the context that a lot of us have been through, sort of taking children from the age of 7 to 17, and the likelihood is that there will be other children living in this neighbourhood who have mental health issues or that who do abuse substances from time to time, and I'm just wondering to what extent that is particularly a problem as opposed to an opportunity for a solution, and with having people who are rather than just sort of parents who are bringing up children who are actually trained in how to deal with those issues, and then with the question of the residents potentially running away. I'm trying to understand what is the sort of the expected sort of particular harm to other residents of a child perhaps going missing and having to be returned to the house. I'm just trying to understand from the perspective of residents, like why that would be a particularly sort of onerous and distressing thing to have happen.
The mental health problems and the substance abuse, all you need to do is look at the SIC code of the operating company on Companies House, and it will tell you what they're operating under. SIC code is a standard industrial classification code. They've chosen that, and the reason they've chosen that is because they will choose children from local authority because it will give them a higher premium. That's a commercial decision. Coming on to your point about what is it so much to be bothered about from a resident's point of view, perhaps not for yourself, but if you were elderly and you had a 17-year-old 6'4" lad jumping over your fence who was mentally unstable and had just done a line of cocaine, I would suggest to you that would be quite frightening. The other thing I'd like to say that there seems to me to be some preconceived ideas. There are at least 3 of these councillors that clearly work in children's care, which is very admirable, but I was under the impression that if you have a preconceived notion about this application, you should remove yourself from the room, because the 2 councillors that have actually been up close and personal to this area have removed themselves from this debate on the basis that they've got a preconceived outcome of their vote.
I'd just like to assure you that I don't have a preconceived.
I wish to make a comment as chair. All of our members have been trained in and understand the difference between a predetermination and a sort of experience, life experience. And I can assure you that all of my members approach every application in the same way. They carefully read the documentation and they make a measured, reasonable judgment based on what they are hearing now and what they have seen themselves and the questions that they're asking. I do assure you of that.
I appreciate that. Thank you.
I have Councillor Ralston on my list.
Thank you. Sorry, I think it's because we've got our technology out as well. So I have am I okay to ask a couple of questions? So my first one is around I hear what you're saying and your example you gave of an elderly resident, but I feel that that's making an assumption about our decision has to be on planning requirements, and we don't actually know any of these vulnerable young people that might be coming here. Yeah, no, I get that. So I just want to sort of say that within the realms of it. And then my question is around the petition, because I've managed to find it. It's not on the planning application, it's under petitions on the website. And it's quite a lengthy one. It's not just a do you agree or do you disagree to this? Am I right in thinking that did you start this petition?
I was one of the residents that were involved.
Okay. Because there's quite a lot, there's sort of 2 pages in it that list all of the kind of the negatives as such. Did you have any residents that were in support of the application?
No one's in support of it now.
Council members, any other members with questions for Mr. Sohan? In that case, thank you very much indeed, sir, and thank you for your time.
Thank you very much.
The next speaker I'm calling to the table is Mr. Daniel Robinson, who is speaking in support of the application.
Good evening, everyone. We'll get this going.
Thank you very much. Radio voice. Okay, good. Firstly, I appreciate it's a Monday evening, so thank you all for being here today, taking the time out. My name is Daniel Robinson, and I stand before you to sit before you today, along with my CRS family member, to advocate for and agree with the request put forward in the Planning Committee report to grant our C2 planning permission with conditions for our children's home at 21 Huntsham, Exeter. This proposal is not merely about establishing a building, it represents a vital step towards addressing the urgent needs of vulnerable children in our community. Exeter, like many cities, faces challenges related to child welfare. There is a pressing need for high quality residential care for children who cannot live with their families due to various circumstances, including abuse, neglect, or family breakdown. By establishing a children's home, we will provide a safe and nurturing environment that meets the emotional and physical needs of these children and hopefully prevents less of our children being placed miles and miles away from county, sometimes hundreds of miles from all of their secure comforts and the things they love and the people they love the most. And it is on this point I would like to reference the ministerial statement published May 2023, which states the planning system should not be a barrier to providing homes for the most vulnerable children in society. When care is the best choice for a child, it is important that the care system provides stable, loving homes close to children's communities. These need to be the right homes in the right places with access to good schools and community support. It is not acceptable that some children are living far from home or far from their counties, where they would call home, separated from the people they know and love. Why is 21 Huntsham the perfect home for children and young people? Firstly, the home is beautiful, as you've seen from the photos today. Our team, our manager, our staff have blood, sweat and tears have gone into making the home perfect. We all would live there. The development itself and the community that comes with it make it perfect for raising children, albeit there are 156 comments that probably suggest otherwise, but I will hone in on that point. There are many professionals throughout the community development, and I believe that together as a home, that we'll be able to continue to create a role modeling framework that other children within the community can look to as well. I believe that we won't just add value to the role modeling framework within the community, but we will actually enhance it as well. In addition to this,
Mr. Robinson, I ask you to conclude now, please, but I will give you a few moments.
3 minutes, isn't it? Wow. Okay. Let's just say this, because it's hard to do this in 3 minutes. We are a responsible children's social care organisation. There have been comments made about restrictive covenants within the development, but yes, by definition, we are a business, of course, because we get paid by the local authority to look after children, but we see ourselves as a residential occupation more than anything else, not a trading business. And even within the development itself, there are other registered businesses, probably 17, 18 or 19 businesses, of which some of those even trade. Now, today isn't about...
I'm now going to ask you to conclude. Hopefully some of these comments will be
Sure.
brought out in questions from
To conclude, I see our children's home as being able to work closely with the community. I've taken in points about having a community liaison, and
thank you, Mr. Robinson. Yes, please. No, if you please stop now, because we have to be fair on both sides.
Thank you very much.
Time restricted everybody, so I apologise for that, but it is the rules. Okay. Thank you. Right, I'm now first of all seeing Councillor Mitchell with questions for you.
Could you first of all outline what your role is? Because you didn't explain. You said we, us, company, etc. I don't understand what your role is. Whether you're a direct provider or just a manager or someone some distance away. So that's the first question. Secondly, you talked about locality, the importance of local children, etc. Does that mean you have a relationship with Devon County Council, and that that would be Devon County Council who would effectively be funding this through the placement of local children? And thirdly, in regard to the issues raised about the type of customer base you're dealing with, can you clarify some of the issues of the type of children you look after, and whether at any one time, because you've only got 3 children, what care is taken about the mix of children you have in the unit, whether it's male and female or single sex, or what the arrangement is? Thank you.
Okay, I'll try to address each and every one of those questions. So I am the founding director of 360 CRS. It's an acronym for Children's Residential Services. That's my role within the organisation. Second question you had was around the
locality. You talked about locality, and does that mean you have a relationship with Devon County Council, or this home is expected to have a relationship with Devon County Council?
Yes, we do. Yeah, we have an existing relationship with Devon County Council.
And the third point was on the nature of the clients who will be your residents of this. What control do you have on who they are, the type of problems and the issues, etc.?
So there is an extremely rigorous, what we call risk profiling that we do for every young person. So every profile that we get, we go through it with a fine-tooth comb, and we do a risk assessment to look at the suitability of not just the home, but the wider areas of the location as well. To add on the types of children, young people, the registration that we have in with Ofsted is to look and care for children who have either emotional and behavioural difficulties, and also learning disabilities as well. When we take a referral from Devon County Council, the local authority, we look at the suitability not just of the property itself, but we look at the suitability of the staff that we have, whether they are sufficiently trained to be able to support those children and keep them safe. And if we are unable to keep them safe, then we are unable to take those children on in our care.
What about gender mix? Do you have a gender mix, or boys at one time or girls at another time?
There's no restrictions on gender, but to add on the process for taking children within the home, we do something called a profile match. So, for instance, if we have, let's just for argument's sake, we have young Amy, and she lives in 21 Hunsham. Firstly, we wait for there's no time on the period in terms of when we wait before we are able to take on another young person. But when we do, and when we believe that they are settled, we do a profile match, and that profile match is an extremely rigorous process. So often we find it's very difficult to profile match. It's very difficult sometimes to get the match with the second young person, let alone the third young person. So that within itself is a framework that a lot of children providers use to ensure that we get the right placements within the home.
How long on average does each client remain with you? The same place?
It can vary. So you can naturally take on a young person at 12 years old, and they can be with you just before they turn 18. So it can vary. It can range from a child, but essentially the home is their home. It's a family home. It's no different to any other family home, except for the family home that we have is licensed and registered by the regulator Ofsted.
Thank you. I have Councillor Banyard next. Oh, yes, then Councillor.
Thank you for your explanation of what your organisation does. We heard from the previous speaker that a residential home in Barrator in Exwick had a resident who absconded 22 times and over a period of a few weeks. And sort of wondering, what would the residents of Barrator Drive, what would be their perception of this event? Would they be completely unaware that this was happening? Would they be very much disturbed by the comings and goings? It was presented to us as a significantly impactful event, but from your point of view, could you explain what those disappearances and reappearances of the young person would look like?
Sure. So firstly, I know the word escaped was used earlier, and I just want to hone in on that. For our children and young people, it's no different to how we will look after our children here. We do not put bolts on doors. Yes, of course, we might have an alarm system around the perimeter of our property because, of course, we want to keep our family safe, but we don't lock our children in. It's not a low secure unit. It's not a localized prison. But when we're talking about children that have gone through abuse, potentially neglect, they have unfortunately suffered certain experiences that we wouldn't hope or wish on anybody. And so when they come into our homes, we are there to firstly work on building trust with those young people so that they are not, they can start to believe in the system again. That's what we're here for. And we're not here to lock these children up. But whilst these children, as any children that does not reside in an Ofsted children's home, can also go through issues, the coping strategies that some of these children and young people have sometimes is that they will run away. And the circumstances and context around the home of Barrator is that we had a young resident who was still localizing, was still trying to become familiar with the home, with the location, and that sometimes takes time. And so you do sometimes get an instance where children, young people will run away, and we do have a process to follow. In terms of how that impacts the wider community, we obviously have a relationship with neighbours. It's very, very much part of what we do as an organisation, that we do like to do outreach. I think the challenges that we've had thus far, naturally, that we've gone into a planning permission pathway that has naturally been highly opposed. And so the outreach at the moment we've been a bit snookered, but the plan very much would be that pending the decision today, we would naturally do the same outreach with our neighbours, and we would invite them into the home so they can see the work that we're doing, because actually we'd very much like them to be part of it. Just like even where I live, we all look out for each other's children. We look out as neighbours, we look out for each other. We'd expect no different as well. I hope that answers your question.
Thank you. Councillor Ketch.
Thank you for your submission. You heard from the other speakers that have already been, and there was some talk about the Barrator residents, which I think it sounds like your organisation run, having a quite curious arrangement under the classification for running the business. It seems that it's not entirely transparent how the business is set up, and it seems to be shifting around classifications. And that obviously leads to ill feeling. Can you speak to that?
Thank you for the question. So I think generally there seems to be a switch with many local authorities up and down the country. You have thousands and thousands of Ofsted registered children's homes with a C3B classification that currently exists. So that's well documented. And there seems to be that same shift towards a C2 classification. And so I think there are many organisations that are seeking consultation on what is the accurate classification. I think I can't remember which councillor it was that talked on the C3B classification earlier, but many Ofsted homes, you know, before registering, sort out a C3B certificate of lawfulness because, again, we point to it, it was always seen as just a residential occupation and no different to any home. You know, we're talking up to 3 children, not. And if you look at the definitions of classification too, they often point to 5 or 6 individual separate residents. We're talking here about 3 children with staff. So we're talking about 5 or 6, 7 at any one time within the home. So currently our classification with Borator is a C3B. And up till now, we've always thought it to be a reasonable classification, but again, you know, we will have to seek consultation on that C3B classification. If that was the question.
Thank you. Are there any other questions from Councillor Jobson?
Thank you. Children who come to you with your granted permission would not necessarily be Exeter or Devon children, would they? They could come from any authority with whom you have a relationship. And that could mean, could it not, that some will have to travel by taxi to schools and that on a daily basis?
So we're currently working with Devon County Council, and we work very closely with them in understanding the sufficiency requirements of Devon County Council. And so our primary placing authority will often be Devon County Council as a priority to place local children within the home.
Can I just clarify? You say, well, you're primarily working with Devon, but if, because of the profiling, which is right, the Devon child isn't suitable, but a child from, say, Dorset is, you would not preclude taking a child from out of area, would you? In the same way that some Devon children have to go out of area as well.
There can be instances where we can take children, young people from another placing authority, and if this were to be the case, often what we're looking at with children and young people is, firstly, as I mentioned, about getting them into a position of them trusting us that we're not going to give up on them. So that's the first thing. So we work on building that. And once our children and young people are settled, then obviously the next steps are looking at things like education, how we can ensure that they are accessing education. And from our good knowledge, we know that there are some good local schools. So we've got a really good local SEN school, and we've also got a very good mainstream school. I believe it's called St. Peter's, which also support the HCPs as well. So to answer your question, we have access to 2 cards, and so when it comes to taking children to school, it would be no different to anybody else taking children to school.
Thank you. I'm asking any other questions from members? Yes, yeah, so, Mr. Robertson, thank you very much indeed for your presentation. Thank you very much. And your time. Now, normally at this stage we will move straight to debate, but I am sensing that we've been sat down for a little while. I am going to call a 5-minute maximum comfort break, please. 5 minutes only, and then we will resume. Thank you. address you before we start our debate.
Thank you, Chair. So we've heard, firstly, the technical planning context of this in terms of the national and local planning policy framework in relation to this specialist kind of housing, which is generally acceptable within residential areas. And it's clear also from the officer's report that this specialist housing is clearly addressing needs of some of our most vulnerable children in Exeter. The officer's report also acknowledges a very large number of objections and related concerns from local residents. And the report gives very careful consideration to any potential impact on residential amenity, but have concluded that this use would not be significant in that regard, and in effect akin to a large family house. There's also been concerns relating, which we've heard, relating to transport and parking in particular, and the Highway Authority, Devon County Council, has raised no objections to those concerns. You've also read in the report that these sorts of facilities are strictly governed by regulatory regimes, some of which have been alluded to as part of the conversation this evening. What I would say, what I've heard as well this evening, is that by far and away the largest amount of conversation that's been had was about really the vulnerable young people that would be living in this home should you grant planning permission, and in relating to that, the care arrangements that will be put in place. I would draw your attention to the officer's report, and there's particularly conditions 2, 3 and 4, which to some extent are attempting to address those issues. And it may be that you want to come back to those conditions when you debate this application. I'd also like to just to reaffirm, again, it's in the report, the management plan has been submitted and is part of the application, which is before you this evening. So just to conclude, there's clearly a lot of emotion involved in this application from all sides, and sometimes it can be difficult to gauge that. What you're here to do as a planning committee is to consider the land use considerations. The report does spell out what they are for you to consider. It also spells out what isn't a land use consideration and therefore should not form part of your consideration. So I will leave it there because I'm sure there's going to be more debate amongst you and may well be questions regarding those conditions, possibly regarding the management plan. And we'll be happy to answer those questions as officers should you wish to ask us further questions as part of the debate. Thank you.
Thank you, Director. I'll just remind our members that the conditions that we're talking about are on page 32 of the report, and there are 5 conditions that would already go with this planning permission if you were to grant it. And obviously it is feasible during this debate for us to debate potential alterations, amendments, or additions to those. I'm now opening it to you for debate, and I'm inviting speakers. I see Councillor Basham first.
Thank you, Chair. I mean, I've listened to both sides. Thank you for everybody who spoke this evening. I'm struggling a little bit to find anything outside of the recommendations already that would be a planning issue for us to turn this down. But one thing that has concerned me during the debate is the apparent difference between what we've been presented with and what we've been told are missing things from the police report, raising concerns from them that we haven't heard about in here, and also something else about the use of the site not being allowed as it is. I think that was, sorry, my head's got a bit funny. Could you clarify those for us, please?
I'm going to ask our officer if you're prepared to respond to that.
First of all, if I understand your question correctly, you referred to the alleged missing information from the police. The applicant was given the opportunity to respond to a point made as a small part of the police's response about how they managed the children in terms of running away and things, which the applicant has explained as well. And the applicant did respond, and that information was incorporated into the report. So we were satisfied that the police concerns had been addressed and were not ignored or deliberately omitted. We were also asking about the covenant issue. When a developer or a landowner sells land or buildings, they can impose their own restrictions on the future use or activity of that land. Nothing to do with planning, nothing to do with being administered by the council, and cannot be enforced by the council, but they can exist. And as we've been told, there is a covenant on this land that prevents the use of business use taking place from these dwellings. But it's not something that the council imposed or that the council would seek to restrict or pursue. Should this application be allowed tonight, the applicant may still need to be satisfied themselves that they're complying with any other restrictions that aren't controlled by the council.
Councillor Jobson.
Thank you. I find this a very difficult application because I do think that the highways issues have been minimised in the report, and I am somewhat surprised. I know the estate is not adopted, but that there is no one here from Devon Highways this evening. The children who will live at this site may not come from Exeter. They may come from other parts of Devon. They will all be children who are within the care system. They will therefore all be have their own social workers in addition to the staff living on the premises. They may require therapy. There will be child in care reviews, which may attract additional movements. So to say that the property would have similar comings and goings to a large family, I think is an underestimate. Now, this particular property is on a somewhat tight corner. Some of the pictures that we have seen show, and there was the letter that was produced from the developer indicated that they were working with Exeter City Council back in June 2023 about the installation of bollards and temporary bollards. And this is a letter from Beth Harris, the Customer Care Office Manager at David Wilson Homes, Exeter. So whatever the rights and wrongs as to whether bollards were going to be installed or not, there clearly was an issue about health and safety concerning Huntston Road and the corner. And if you take also children may be in education, certainly in Devon, the norm is for children to go to school by taxi accompanied by a worker rather than just sit in the passenger seat with a care worker because of the exceptional needs of the children. And so twice a day, there may well be more traffic movements as well of children coming to and from school. Not all the children would be able to go to school all day, and so movements may be spread over a different period of time. So I do think that that has been underestimated and perhaps not sufficient consideration given to the impact that traffic is going to have on the residential area. And it does concern me that is the case. Thank you.
Thank you very much, Councillor Dobson. Any other speakers to this? Councillor Mitchell.
Thank you. Just really a question to the officers. Looking through the 5 recommendations that you've got here, sometimes, or normally when we have larger scale developments involve multiple people living together, we have management plans and schemes associated. There's nothing here related to anything that might relieve some of the pressure that local residents feel about access schemes, management, control, etc. Whereas in the past we've tended to insist on that being a requirement of the planning permission. Can you explain why it's not included?
The reason, normally when we ask for those things, it's because the applicant hasn't submitted them as part of the application. In this case, we already have a management plan submitted with the application, and you'll see condition 2 requires compliance with the submitted information. So we're satisfied that that already exists.
I just think that could be more clearly stated in the actual resolution so that people have got that reassurance. It does exist, it is acceptable to the local authority. That's why there's not a distinct separate condition regarding it. Thank you.
Just give me a moment just to ask for advice, please. Right, okay, so we're going to continue with our debate, but we are opening up the possibility of us specifically writing in additional clauses or wording in these conditions. Any further contributors, please? Councillor Paul.
So this is actually going back to the officer's report. So I'm just looking at it, and it does appear that there is what presents as a walkway outside of the curtilage of the residences along Hampshire Road. And it's grass, but it does seem to fall outside of the boundary of the houses. So just like wondering if that is your understanding that people would, that it would be customary for people to walk along the sort of grass verges if they were going to walk along the length of that road.
I don't think so. I mean, I've got a bit of experience of this kind of because I live in an estate which is arranged like this, and it's kind of a home zone design where the services are in a strip of land that's not owned by the property owner running along either side of the road, but the road is designed as kind of shared surface so that it would accommodate pedestrians and vehicles, and the theory behind it is the vehicles drive more slowly because they're sharing the space with pedestrians. So the grass strips you're referring to are not designed to be pavements in the same way that you would find on a more traditional street.
I just feel like if I was walking down that road, I would, well, if there were traffic, I would walk along those grass strips, and I don't know if a resident whose house it was would be able to yell at me to tell me to get off their garden, or is it? It's not owned by the resident. It's a sort of no man's land.
I don't know in this case. I know in my personal experience that it's actually the Highway Authority, although this estate isn't adopted. Highway Authority has control over that strip, although it appears as part of my front garden. But in a way, it's not entirely material to this application because we're considering the difference between the proposed use and an established use. And I think that those issues would be the same regardless.
Councillor Atkinson, at various stages there, I'm afraid I was cutting you off. Would you like to now make your points?
Well, I've listened very carefully to everybody, and I think that the advice of the planning officer in this instance, is very, very clear on all material considerations for planning, and on that ground, I really agree with the councillor over there, or whichever it was, and that couldn't find any valid legal reason which we could reject this application, and that's just a statement of the law.
Thank you very much, Councillor. Councillor Ross.
Back to the point that was raised a couple of times about having a sort of named liaison. Is that something that we can put into the conditions? Is that within the legal framework?
it's not, it isn't a feature of the management plan that's been submitted. So if we were to require further details of community liaison, then that could form a separate condition to supplement the information that's in the management plan. And this is something we do quite frequently with student accommodation, where there is a requirement to submit details of how neighbours can contact somebody in the event of there being an issue. So I don't see any reason why we couldn't have an additional condition requiring the applicant to submit those kind of details that would be then, and how they would be made public so that local residents would know who to contact in the event of a problem.
Thank you. Again, Councillor Ketchin.
Can I just clarify that we're at the discussion and rounding up phase?
What we're doing at the moment is we're discussing we're debating.
Not closing up.
No, we are debating, and then if we feel that we need to amend, alter, or add to conditions, we can do that in debate. We will need to debate those first, accept those into the motion, and then again do a vote on the actual. Yeah, as with anything, there has to be a proposal and a seconder for that when we get to that stage. First of all, I'm inviting members to contribute to a debate on what they have heard. And no, Councillor Ketchum, we're not rushing this through and looking for a conclusion. We're wanting to discuss this in full. But do I have any other contributions, please? Councillor Bennett.
Thanks, Chair. I just want to ask regarding condition 5, is there a green travel plan in existence? Have you seen it? Is there one? Thank you.
No, I don't think there is. It's the reason why we've imposed the condition, so that we can receive one and assess it to make sure it's appropriate in accordance with the aims stated in the reason for the condition.
Sorry, me again. I've got a question. This question around, I'm just going back over through some of the reports and things. And there's this thing that was raised about the, I'm not sure I've written it now. The types of children that are going to come in. Again, I might not know, but from what I've had a look at, I think that referral was to the company's house standards, whatever they call it. Thing SEC, no, that's the wrong term. You know what I mean, don't you? SICs, thank you, sorry. And those are just sort of you have to fit into one of the boxes rather than they've actually said that's what's going to happen. So that's almost, sorry, you go with my thinking. That's almost separate, isn't it? Because that's sort of a company's house kind of thing. Whereas the information we've got on the planning application is what we're kind of going through. Is that right? Thank you.
All these things, we are looking at the application in front of us and not in assumptions or extensions or other things that could or might happen. Unfortunately, we are not Mystic Meg. We are simply looking at what we have in front of us. At the moment, not seeing any other hands up. So now at this stage, normally I would move the motion in accordance with the officer recommendation in order to see what you're doing. But I am feeling a sense that we need to discuss these conditions. I'm going to Councillor Mitchell first.
Once the motion is proposed and seconded, and then possible amendment.
In relation to particular 2, without adding too much wording to it, at the moment we got the reason is to ensure compliance with the approved drawings, and I would say and submitted management plan to include community contact details. I don't know if community contact is the right phrase to use, but planning officer come up with a better phrase there, which I'm missing at the moment, so we know that they're there. And we've got the existing plan, so at some stage the planning officer, if this agreed, can sign that off.
Thank you, Councillor Mitchell. So I think that's subject to the chair, and then someone proposing that you can look to vary condition 2 along the lines of suggesting. What I would say is that if you want to insert something around the management plan that's been received, that could form part of condition 2. If you wanted to go further and require details of the community liaison, because that doesn't form part of the submitted management plan, which deals with the people who are going to be living in the home as opposed to external, then you can also suggest that there's an additional condition that's related to that.
That's probably why I use initially my wording was and submit approved drawings and submitted management plan, because we already knew that had occurred. Once the issue was raised about community contacts, etc., I thought to include that could be added on the end, or whether you wanted to make it a separate condition. I'm just trying to save words or whatever.
My interpretation of this is that you have proposed additional words to condition 2 at the end of condition 2, after the word drawings, to include the phrase and submit and the submitted management plan that has been received. And looking for a seconder for that amendment. I see it in Councillor Jobson first, was the first one I saw. Would you like to speak to that, or would you like to go straight to it?
Just assuming that you'll deal with the community contact issue as a separate issue now. More than happy.
Right. Okay. So I have. Does anybody wish to speak for or against this proposed amendment to the condition? Okay. In that case, I'm putting to the following vote that we alter or add to the phrasing of condition 2 and submitted management plan that has been received. For those in favour, can you please indicate? Any against? Any abstentions? One abstention, please. So that is carried into condition 2. I'm now asking, would anybody like to, Councillor Ralston?
Yes, I'd like to suggest an additional condition. I think whilst we are here to have to look at the planning reasons and take out the kind of emotion from it, I think that we should have a condition that supports the provision of a, I don't want to say named person because that's the wrong thing, but named position or something for a community contact, or that there should be a community contact information made available to local residents.
Can I ask officers if they could come up with an instant wording for that, or would we want you to?
I'd be slightly reluctant to go up with an instant wording. I think we need to refer to what we've done before, and I know we haven't done it before precisely for this. We've certainly done it for student accommodation, and it would be very similar. And we ought to try and be consistent with that. So if you're prepared to delegate that to us, we will come up with a simple form of wording that makes sure that the community liaison details are required, and how they will be made publicly available is also a requirement before we'll discharge that condition, and then that the use shouldn't come in until we've got that information and it's satisfactory.
Right, so before I put that, Councillor Jobson.
Yeah, can it be clear that that point of contact is either 24/7 or that there is, there's a nighttime number and a daytime number?
Okay, so what I have before me is a proposal from Councillor Mitchell that we insert a condition 6, which will be Councillor Ralston. My apologies, Councillor Ralston. That we will delegate to officers the phrasing of a condition 6, which is the provision of means of a point of contact, effectively a liaison between the business and the community.
I thought it was to delegate the making of that.
Yes, to delegate the phrasing to an officer, but for that to be the substance of the condition. Is that correct, Councillor Wilson? I'm looking for a seconder for that. I'm seeing up from Councillor Espashian first of all. I see of hands. Does anybody wish to speak to or against that addition? Now, in that case, I'm going to put that additional condition into a vote. Those in favour of inserting the condition 6? Seeing all but one. Any again? You're abstaining, Councillor Kitchen.
That is carried.
Yeah, that is carried. So those 2 new conditions go in. I am now going to move the motion in accordance with the officer recommendation, and I'm looking for a seconder for that proposal. Yeah, I see Councillor Atkinson. Seconder. I'm asking now, does anybody wish to speak for or against this motion that has been seconded? The opportunity now for you to, yes.
I'd like to say something.
Okay, Councillor Ketchum, please do.
It's not a for or against thing. It's not a for or against thing. But I know in my community, when the start of the Ukraine war, many people were displaced and came to Exeter, and they ended up very near my front door. And there was a lot of dissatisfaction with the council's response, and it might surprise you that the dissatisfaction was that the local community hadn't been given the opportunity to welcome these people, and so that moment was lost. And I just sort of, when I spoke to people who were onto the back of this facility where these largely young men were arriving, I was quite surprised to hear that. You know, it was a, why haven't we been allowed to welcome these people? I have a care home in Newtown that that's relatively new, and I've never had a complaint about it. I can't comment about the demographic of people there. And I know there's also a councillor who's been through the care system and has continuing to contribute to the community. I think there's been a lot of talk about parking tonight. I haven't really heard a compelling argument about parking, but there is an issue here about how we perceive what community is, and it's tough for everyone when communities are shaken up. But we've got to understand that community is a wide concept, and not sometimes a dynamic thing, and it's sometimes something to try and embrace with open arms.
Thank you, Councillor Ketchum. And I am now going to call for a vote on the motion as put to you. This is to accept the officer recommendation to grant planning for this location, with all the conditions 1 to 5 as listed in the recommendation, with condition 2 amended to include a management plan, and a condition 6 inserted with delegated powers back to the officers for the phrasing of that. Can I see those in favour of that motion, please? Now seeing a unanimous call, in that case I'll no need to call for, against or abstentions. That is carried. Thank you very much indeed for all of your attention on that. I can now invite the councillors who recused themselves to come back in as we continue the business. Thank you all very much indeed for your attention and contributions to that matter.
Just want to ask one question. I live in number 19, which is where the White Van is. Omar was represented in his house, number 23. With any of you people,
sorry, sir. This is not the time to make this comment.
Take it on with it. Take it on with it. Would you buy my house now?
Sorry,
I'm
sir.
not liable. Just answer the question. Would you buy my house?
If I had the money, of course I would, but I can't afford to live where you live, sir. Yes, please. Thank you. Can you please leave, sir?
About £6,000 a week per child.
Sorry, sir. The members.
So what type of child is going to go into that house? It's not a children's
Can you please leave, sir? Thank you.
Passion, sir. Passion.
Students on the stretching campus. Yeah, we thought we lost it by 1 point. When take myself in person, there was a copper in the day in the area and attended a few deaths of students who were not there's some funding of railing that's slowly got blown away ever since. Submit something to that transport plan of 4,000 students are going to be moving around that area of the city, which doesn't have payments on one side because someone was ill that day and they didn't bother to find a replacement and there was no transport plan.
All right, thank you, members. If I can call you back to order, please. We are on to agenda item number 6. Agenda item number 6 is to consider the report of the Strategic Director of Place on a list of decisions made and withdrawn applications. You have had that list issued to you in advance. You have had an opportunity to scrutinise it. Does anybody have any comments or questions to make to the Director on this list of decisions made and withdrawn applications? In that case, I'm calling for a simple vote to agree that we have considered and noted the report. Those in favour? Thank you. That is unanimous. That report is noted. We have moved on to item number 7, which is the appeals report. Again, we are considering the report of the Strategic Director of Place. You have had this report. You've had an opportunity to look through the appeals. Councillor Mitchell, do you wish to?
I just want to ask a generic question. How are we doing in the Premier League table on yeses and nos? Because we were somewhat concerned some time ago. I just wonder how we are. We Manchester United or we Liverpool? Well, who do we want to be?
Order, please. We will have an answer to the question, perhaps in more planning terms than footballing.
Thank you for asking that question. And we do have a duty to periodically submit information to the government on our performance on appeals. I'm slightly ashamed to say I don't know precisely how well we're doing at the moment. But I think it's a very reasonable question. So I need to. I mean, Matt Diamond in my team is good at maintaining the stats on how well we're doing on appeals. And as far as I know, there isn't a concern. But I think, before the next planning committee, I will make sure I've got the actual facts in front of me. Yeah.
Thank you very much. Are there any questions relating to the appeals that have been listed? In that case, it is a simple vote to note the report. So are those in favour of noting the report? See, unanimous. Thank you very much indeed. We have come to the date of the next meeting, which will be on Monday, the 11th of November. I thank you all very much indeed for coming. I specifically thank Councillors Millerbaum and Hussain for sitting for so long outside and actually doing your civic duty in terms of declaring your wish to recluse yourselves. It was very much appreciated that you've attended, and thank you all those who have sat through this debate. Thank you for your attention to the matters. Thank you for your consideration and for your contributions. Good night, everybody. Thank you. Please remember to sign the fire list as you leave. Thank you.